They said 11 celebrities got pulled into the case. Headlines went wild, timelines melted. But here's the honest version. In a federal courtroom, names can surface for a bunch of reasons. Context, background, witness familiarity, even just to make sure jurors don't get starstruck. And none of that automatically equals guilt. Tonight we're cutting through the noise. What actually happened at trial? What the jury decided? Why so many big names were read in open court? And what's coming next? Quick ground rule before we dive in. Everything here is sourced to public reporting and court records. Mentions do not imply wrongdoing. Combs denies the most serious allegations. The jury acquitted him on those, and he was convicted on 2 lesser counts. Sentencing is next. Let's start with the scoreboard because everything else flows from this. In July 2025, a Manhattan federal jury acquitted Sean Diddy Combs of the most serious charges, sex trafficking and racketeering conspiracy, but convicted him on 2 counts of transporting individuals across state lines to engage in prostitution under the Mann Act. Translation: the jury rejected the government's trafficking and RICO theories, but they did find him guilty on 2 transportation counts. He remains in custody and is scheduled to be sentenced on October 3rd, 2025. Reporting indicates federal guidelines could point to a sentence around 4 to 5 years, though the statutory maximum on the 2 counts is higher. The defense is pushing for less time. Federal prosecutors in the Southern District of New York unsealed an indictment in 2024 that laid out a sweeping case. They alleged years of coercive conduct, a network of associates, and drug-fueled freak-off events. Combs pleaded not guilty. Months later, the trial began. Weeks of testimony, cross-exams, and arguments. After deliberations, the jury narrowed the story to those 2 Mann Act convictions and said not guilty to the racketeering and trafficking counts. Whatever you think of the culture war noise, the legal bottom line matters. The top charges did not stick. One decision shaped the tone. The judge allowed jurors to see the 2016 hotel hallway footage showing Combs assaulting then-girlfriend Cassie Ventura. The defense argued the video was prejudicial or manipulated. The court said it was relevant background and admissible. You don't need me to describe it. The footage has been widely discussed, but know this. It was legally greenlit for the jury in this case. You've heard her name for years. Ventura filed a civil suit in 2023. It settled quickly without admissions. In the criminal case, she testified and was cross-examined for days. Prosecutors framed her as a key witness. The defense pressed credibility and context. The jury's split decision tells you how complicated juror calculus can be. They didn't buy the trafficking or RICO counts, but still convicted on 2 transportation charges. Here's the part that confused a lot of people. During jury selection, potential jurors were shown a long list, roughly 190 public figures and associates. That's routine in high-profile cases. It helps find jurors who can be impartial even if a familiar name pops up later. It also limits surprise and bias. Media coverage then highlighted some of those names. Michael B. Jordan, Ye, Kanye West, Kid Cudi, Britney Spears, Mike Myers, and more, and social media did the rest. But the purpose of that list is context, not everyone's a suspect. High-profile trials do something that looks dramatic but is actually routine. During jury selection, the court reads a long roster of familiar names to flush out bias. If a potential juror lights up at a celebrity, good or bad, the lawyers need to know before testimony starts. That's why you saw headlines about dozens of stars connected to the case. It wasn't a dragnet, it was a fairness check. Mentions in court or in media rundowns are context, not charges. Here's what that looked like on the ground. A handful of A-listers appeared on those lists because they've crossed paths with the people at the center of this story, shared events, overlap in work circles, or simple name recognition that jurors might have. Some were referenced in reporting for clarity. In at least one instance, a music artist testified about a past incident from his own life. The point of his appearance was to tell his story under oath, not to suggest he was under investigation. For the rest, being named on a juror questionnaire or in a media recap just means the court anticipated those names could surface and wanted jurors prepared to hear them without overreacting. So when you hear 11 celebrities pulled into the case, translate it the careful way. Mentioned doesn't equal implicated. It means the courtroom expected overlap and tried to neutralize it. Keep that filter on, because up next we're breaking down what the government actually alleged and why the jury drew a sharp line between those allegations and the 2 counts that did stick. Prosecutors painted a wide canvas: a powerful entertainer, a network of employees, and a pattern of coercive encounters, plus the infamous freak-off events. They leaned on witnesses, messages, travel records, and that 2016 hallway video to sketch intent and control. The jury listened and then split the difference. No on trafficking and racketeering, yes on 2 transportation counts. If you've watched enough federal trials, you've seen this before. Jurors often carve out a narrower middle when the big conspiracy feels too expansive, but specific acts feel proven beyond a reasonable doubt. The defense answer was simple: adults, consensual encounters, and a case inflated by sensational coverage. Post-verdict, Combs' team moved to challenge the 2 convictions and has continued arguing for release before sentencing. So far, the judge is keeping him detained pending the October 3rd hearing. Between now and then, both sides file sentencing memos. Expect big arguments over who counts as a victim under the guidelines, how to score the offense level, and whether the court should go below or above what the guidelines suggest. Judges don't admit evidence to make a point. They admit it if it meets the rules. Here, the court found that hotel footage relevant despite defense objections. Practically, that gave jurors a visceral anchor, something more than "he said, she said." Did it decide the whole case? No, the acquittals proved jurors used a scalpel, not a sledgehammer. But it almost certainly shaped how they weighed credibility and intent on moments tied to the Mann Act counts. The Mann Act is old law with modern teeth. In simple terms, it criminalizes transporting someone across state lines for prostitution or other illegal sexual activity. It's narrower than trafficking, and that's the whole point. You can be not guilty of trafficking, but still guilty of transportation with the required intent. That's the legal needle the jury threaded here. You don't need a law degree, just remember, transport plus intent equals felony, which is what stuck. Celebrity lists are gasoline in the attention economy. Variety references a 190-name roster read to jurors. Other outlets amplified a handful of A-listers. Social media turned mentioned into involved, and suddenly you've got 1,000 thumbnails. But in this courtroom, the jury's job was to filter out noise. That's literally why those lists exist. To avoid bias, not create it. So when you see 11 celebrities pulled into the case, translate it correctly. Mentioned, not charged. Sentencing isn't just a number, it's a public statement of values. The judge will look at the guideline range, the nature of the offenses, conduct proven at trial, conduct the government says is relevant, the defense's challenges to that relevance, and the classic factors: punishment, deterrence, respect for the law. Prosecutors have hinted guidelines could land roughly in the 4 to 5 year zone. The defense is angling for far less and will likely highlight support letters and favorable statements to argue these were consensual adult encounters. Either way, the sentence sets a tone for future celebrity cases that mix adult conduct, power dynamics, and social media megaphones. Here's a detail to watch like a hawk. Reports say prosecutors want many of the escorts and participants counted as victims under the guidelines. The defense argues some of those same individuals told investigators their encounters were consensual and shouldn't count. That's not just a semantic fight. It can end up moving the guideline range dramatically. Expect ceiling fights, redactions, and last-minute letter wars. If you see headlines about escorts supporting the defense, this is what they're talking about. Even once the judge announces a number, questions linger. Will the defense win a motion for acquittal or new trial on the 2 counts? Will appellate courts change anything? How will civil suits proceed now that a jury narrowed the criminal case? And what happens to the culture conversation that exploded when those 11 names trended? Legal answers move slowly. Cultural answers move overnight. That tension is the new normal. When a case like this hits the feed, it becomes a Rorschach test. People see what they're primed to see. Here's the calmer view. A federal jury rejected the heaviest accusations and convicted on narrower acts. A judge, not the internet, sets the sentence. And those 11 celebrity names? They tell you more about how small fame circles are than about who did what. If you want the day of sentencing breakdown, what the judge says, what it means, and how it ripples through the rest of the story, hit subscribe and keep your notifications on, and we'll see you next time.